Probably the most important factor that a prospective buyer in a condominium or HOA association should be aware of is whether or not there are any delinquencies that the prior owner owes to the association. And that may take the form of regular maintenance or assessments. That may take the place of special assessments. There could be late fees and attorney's fees that have been incurred because the new owner, unless it's some type of special circumstance such as a tax deed sale, the new owner is going to be responsible for the prior owner's obligations for those delinquent assessments. So usually what happens is that there's a request from the association for an estoppel letter which details all that, so the new owner knows what kind of money they're going to owe, if any, to the association before they close on the property. And those figures may be right and they may not be right, and that's one of the roles of the association attorney, is to try and figure out and make sure those figures are correct. And then if there's an attorney that's representing the prospective buyer, it's important to look those over and to make sure that the association is not overcharging the prospective buyer. The other thing I think that's the most important is that the associations are required, whether they're condo or HOA, to have their governing documents recorded, or at least most of them. There's a declaration of covenants or a declaration of condominium. There are the bylaws, which are also recorded. The articles of incorporation are recorded. The only other governing documents that usually are not recorded are the rules and regulations. But in all those documents, along with the Florida statutes, they govern what the association can restrict, and the procedures that the association would have to go through to enforce such restrictions. So if an owner had a question about whether or not they were able to bring their pet with them into a condominium association, well, they have to review the governing documents on that. And that gets a little tricky because it may be in the Declaration of Covenants. Something like that typically wouldn't be in the bylaws, but you really have to check all of the governing documents. Certainly maybe in the rules and regulations. So you need to check all 4 of the governing documents to make that determination. One of the other things that people get tripped up on when they try and do this themselves without help of counsel is there are also amendments that are recorded after the original declaration is filed or the original bylaws. And so you have to search the public records very, very carefully to make sure that there hasn't been some type of amendment to the original declaration that changes the particular restriction that the owner is interested in. And as I stated before, they may be interested in modifying their unit or their house. So they need to look at those kind of terms within the declaration and to see how specific they are and to see how restrictive those terms are, and what kind of boards you need to, an owner needs to get approval from to make such changes to their property. There are also parking issues, and without looking at the declaration, you can't just rely on what the seller's telling you. You can't just rely on what the property manager tells you. You have to look at the governing documents to make sure that you understand completely, or the owner does, what kind of restrictions that they're going to have and they're going to have to live with.